Anything that's not, anything that's objectionable, we object to. So, yeah, it's very invasive, but when you're getting divorced, there's no privacy and they're allowed to ask for anything that possibly discoverable evidence. So everything that they requested is appropriate. Okay. All right, we'll let you know when we get his documents. Bye. Hi, everyone. I'm going to give it a few minutes to let everybody in. Can someone who's on camera, hey, Karen, can you let me know if you can hear me okay?
I can hear you good.
Yes, we
okay.
can hear you.
Okay, cool. Just a few more. All right, let me get my PowerPoint pulled up. So I'm doing a CLE for my local bar, and I probably should have asked this before I agreed to it, but they gave me a 2-hour time slot. So I don't really know if I can fill a 2-hour time slot, but I just kind of put my presentation together, and I'm just gonna see how long it takes for me to run through all this. All right. Presentation mode. Okay, you guys can see my screen?
Yes.
Okay. Cool. I get this over here. Way too many screens going on. All right, give me a second. So my entire screen has frozen. So when I put it in presentation mode, the whole thing froze. So I think I'm just gonna share the regular PowerPoint, and that's just gonna be what it is. So, but you guys can see this, right? Okay.
Yes.
Okay, cool. All right, well, then I'll just get started. I'm planning on plowing through it, but the presentation that I'm doing at the seminar, I kind of expect will be interactive. So if you have any questions along the way, just kind of, fire them at me. Wait till I finish this sentence. But if you have any questions about anything, then just let me know. So this is the link to the materials if you want them, tinyurl.gwinnett.cle, so you can download this PowerPoint if you want to. It's got 143 slides, so it's a lot. but it also has some links and stuff in it. So the easiest way to get the links is to download the PowerPoint. So I usually start my presentation giving a, bio about me, which is this kind of, what people think I'm doing and what I'm actually doing. So like for right now, you don't want to know the bottom half of the situation. So basically my work sort of lifestyle is sort of meant to be remote. And I started doing this years ago. So in 2016, I was kind of having like an existential midlife crisis, and I was tired of doing custody cases and all that. And I just knew that I needed to do something different. Otherwise, I was just going to explode. So I decided to move to Arizona, and I just did. And I started by doing a sabbatical, and then I decided that I was going to run my Georgia firm from Arizona with absolutely no clue how I was going to accomplish it. I was just going to wing it, and that's what it was going to be. So I became fully virtual in 2016. So I extended my stay in Arizona past the 6 months, and I stayed there for 3 years consecutively. So occasionally I would come back for hearings, but that just kind of allowed me to figure out how to run a firm remotely well before a lot of litigation attorneys were doing that. So that kind of actually set me up well for COVID. So that actually, the genesis of the group was I started it in 2019 because people were asking me about, my, virtual firm, and the fact that they followed me on any other social media. They saw me in Arizona all the time, which looks way different than Georgia. So I wasn't in the state where I practice all the time. So I set up the group, and then of course COVID hit, and it just kind of blew up because people kind of wanted to know how to, lawyer virtually and how to apply tech to the firm. So I love tech. I've always loved tech. My major was going to be computer science, so I would have continued with it, but I wanted to finish college year early, so I just picked the easy one, which was political science. So, but I like this stuff. Not a lot of people like it. I do. So that's just kind of how I kind of got into this. And I've just decided that there has to be a way to use tech to sort of enhance the client experience. And I think sometimes people look at it like, am I trying to replace talking to my clients? And I'm not. And I don't think that it feels impersonal the way that we do it, but we'll see. So I'll just kind of go through the slides. Okay, great. No questions so far. This is my bio. I'm going to skip through most of this. I have been practicing for 22 years. The last 15 years is flat fee. So that is a big part of this drive for me anyway, to be really efficient, because it's financially beneficial for me to be efficient. So even when I was billing hourly though, I still was I just didn't understand all of the things that my firm wanted me to do when it didn't seem necessary. And I really kind of started developing systems then that I used on my own to kind of make it more efficient. So anyway, that's my bio. I just used ChatGPT to come up with this, which is there's some ethical concerns regarding tech and law offices that obviously everybody has to be cognizant of. Data privacy and security is one of them. Everybody's heard the horror story of LastPass, where they, I guess, compromised everybody's password. I never used LastPass, so I can't really comment on what that would have done to my psyche, but it wouldn't have been good. So that is always going to be a risk. Unauthorized practice of law, I honestly think a lot of the tech tools out there cross over into that boundary. So I feel like if people are putting up portals and saying, I'm a paralegal, and these are the forms. And I personally think that's unauthorized practice of law. If you're telling someone what form to fill out, that's practicing law. So that's just something to consider. Of course, there could be malpractice and negligence. It's supposed to aid, technology is supposed to aid us in lawyering. It's not supposed to replace it. So that I kind of keep that in mind as well. There does have to be some actual lawyering at some point. And of course, there's an access to justice issue. So technology can be helpful, but obviously not everybody has access to computer, Wi-Fi, all of those things. In my personal practice, I do family law and divorce. So it's not like it's criminal. So I'm kind of like 100 or 0. So I have clients that are really tech savvy and honestly have a lot of money to charge a lot of fees, or I'm doing pro bono stuff for domestic violence victims. So that kind of assuages my kind of sort of guilt over this, because I frankly decline people that aren't able to use my tech tools. I ask them the initial consultation if they are okay with scanning and a paperless office. And if they're not, I decline them and refer to someone else. I understand that not everybody is going to do it that way. You don't have to do it that way. That's just personally how I do it, because that's my business model. It helps me run my firm more efficiently because I'm flat fee. But that's just something to kind of keep in mind, that obviously there can be friction between the technology you're using and the client base that you want to serve. And you may have a completely different client base where you are going to have to scale back a little bit on the tech in order to serve the people that you want to serve. So this is just kind of the agenda. I'm going to talk about, it's 4 sections. I'll talk about intake. I'll talk about improving the client experience throughout the case and how to use tech for that. Tech for basically preparing the case for trial, or mediation is the same thing in my case. And then the actual presentation of it, how I use tech pretty much all throughout it. So I think this one's out of order, but yeah, that's fine. So we'll talk about intake first. Let me put a few more people in. So in terms of what I do at intake, I designed an intake process that my firm and my clients. So some of the things that I do, you're going to think are crazy, probably. You're not going to want to do, and that's fine. But the point is to have a system that works best with your firm. And I'm leveraging software and services to kind of just streamline intake at my firm. So I get a lot of calls a day. It's probably like 15 to 30 new client calls a day. And I don't have a receptionist and I don't have a dedicated intake person. So if I had someone that was fielding all of those calls from the jump, it would be a full-time job, and I'm cheap and I don't want to pay someone full-time to do it. So I use software, which is only $250 a month, to really sort of narrow that funnel down in terms of my response time. So it doesn't require a full-time job anymore. Your intake form can be turned into a tool that deploys your specific marketing campaigns and strategy. And I think really the most important part is make the client feel like they're working with you from the first moment of contact without you really having to do anything, because that's kind of what we're doing. They feel like they're working with us from the beginning, even though at that point I really haven't done anything. Okay, so does someone have a question? Nope. Sorry, I skipped the whole. So how do you design the intake process? You design the intake process by figuring out your criteria, map it out, and I'll show you my map later on. Document it, test it, and break it. And I always tell people you're not married to any specific process. So you may go down along a path for a while and then say, yeah, this isn't working. So don't be afraid to try something else. I'd recommend changing one little thing at a time and testing that for a while before trying to change everything, because that way you're never going to find out what the thing is that went wrong if you change everything at once. Time test it, you can catch errors, fill gaps, delegate, to make sure you're delegating a lot of your intake process. I don't think the attorney should be the person on the front line. People have different ideas about that. I don't think an attorney has to answer a call in order to close. I think, honestly, attorneys have egos sometimes, and we think, well, we can, sell ice to an Eskimo and we can convince people better than anybody else on our team. But sometimes I feel like you're not giving enough other people the credit. And I think it also matters too, that if your process and your workflows and your systems are a certain way, the person that talks to them later is less important, because by the time they talk to that person, they've already gotten emails and texts and links to videos and a client guide. They've already gotten a wealth of information by that point. And they feel a little more invested in your firm than if they hadn't gotten that information. Just decide what system to use. There's no right or wrong way to do it. I, again, don't have a receptionist. I don't have a person in house. I have an answering system. The answering service answers the call, does the initial triage, and then puts it into the CRM. And then, of course, you need to develop your script and then workflows and then step at every test. So my script is posted. I'm not sure if it's in this PowerPoint. It probably is, because it's 143 slides. You obviously don't have to use my script, but it may help you in sort of developing one. So this is the ChatGPT response to how to create an intake process, which I think is pretty close to kind of what I decided anyway, but I was too lazy to put it in paragraph form. So ChatGPT did it for me. This is kind of something for you to think about in terms of who's finding your firm, how are they getting to your firm? Because how they get to your firm, I think, matters of how you respond to them in terms of if they're calling, text, I think are a good way to reach out. And honestly, I was not on the text train for a really long time. I just, with family law, I didn't want it to be too informal. I resisted it. But honestly, I was getting a lot of issues with declining people. They would call, I would look at their case, I would decide, yeah, I definitely don't want that. And I would send them a very nice email saying, I'm so sorry, we can't take on your case on this at this time. Here are some resources, but people don't read emails, I discovered. I don't know, maybe it's a generational thing, but they don't read their emails. So that's when I decided I had to have a system where they get a simultaneous text. So we do send the emails, but we send the text as well. And that has cut down a lot because we were getting a lot of call back saying, we haven't heard from you, even though we'd sent them an email. And that was honestly just pain behind. So the texting definitely helped things. So find out where people are calling, how people are coming to your firm and contacting you. And I think that'll help you figure out, the rest of your intake process. So what happens when clients find your firm? You can have unqualified and cold leads, website visitors, qualified leads, then they complete the intake, you have a consult, and then they're retained. So for the unqualified cold leads, those are the ones at the top of the funnel I have filtered by the answering service, and they're actually pretty good at it. So I have a list of things where I basically tell the answering service to just get rid of them politely. For example, if DFACS is involved, which stands for Department of Family and Children's Services, like CPS, I want no parts of that. Like, no judgment for people that want to practice that type of law. I don't have the mental energy for it anymore. I just don't. So anytime a client says that DFACS is involved in their case or their children are in foster care, they just get declined. So that helps, because if I'm getting 15 to 30 calls a day and I don't have to return a percentage of those because they're not qualified from the beginning, then that definitely helps me. So what are my other disqualifiers? Obviously, if someone's rude, they don't get to the next step in the process. If they say they don't have or do not use email, they do not get to the next step in the process. I can't remember all of them, but it's on my intake form, and yours are going to be different. Obviously, the population and the clients that you serve might be different. So you may have different criteria, but you're going to have some criteria. So you can sort of at least take off that first level with an answering service or with the first initial call. So this is just something I thought was interesting in terms of the gap between our perception and clients' perceptions. Like, there is a culture of immediacy. Clients expect you to respond immediately. That's 82%. And, lawyers will let people go to voicemail. I hate voicemail. I don't let people go to voicemail. But that also doesn't mean I'm going to answer the phone either. But I think it's interesting that there's a gap there. And I don't like that that's the case. I don't subscribe to the culture of immediacy. And I honestly wish most people would just calm down, like, especially in a divorce case. Like, you hated this person for 20 years. Like, you can wait 20 minutes for a call back. So, but that's just kind of a gap, and we have to fill that gap. And I don't have to fill the gap by running to the phone and answering it, but I can fill the gap by, as soon as they call and they're a qualified lead, they'll get an email and a text within 15 minutes. I build in a 15-minute buffer because I have time to cancel the workflow if I know it's something that I absolutely don't want. So there's a way to give them an immediate response without me actually having to do anything. And then there does seem to be an issue with clients saying that firms it's not, initially responsive. And then, lawyers think that they're responsive, but, sometimes they're just kind of not. So there's just a gap between what clients sort of see and then what lawyers perceive themselves to be. So in terms of urgency, 40% of clients are saying, hey, I really need an attorney right away. And then only 15% of lawyers sort of sense that urgency. So there's a gap there as well. So, I mean, there's a bunch of things I could say about it in terms of, sometimes it's not urgent, but I think that's just kind of the world that we live in. When people have a problem, they want it solved right now. So there's kind of a way for us to balance between sort of seeing their need for urgency, but also sort of letting them know, like, what your process is and what the timeline is, adjust their expectations, which may not be realistic. And it might be because they watch TV a lot and they watch The Good Wife. And it always just kind of amazed me, like, she'd have these class action suits that would go to trial in like a month. I'm like, how is that even possible? So I think people just might have unrealistic expectations about, the process and all of that. So I think it's our job to educate them as much as we can from the beginning. So they're not feeling sort of lost in the process and they're not expecting things to happen a lot quicker than they actually are. So these are just some ideas of why attorneys may struggle with the intake process, because clients want a response right away. So with some practice areas, for example, personal injury and criminal law, they want help right now. If they've been in an accident, they're hurt, they were given a number, they're not going to wait for a call back. They're going to hang up and call someone back. So, your intake process should match what yours, what your practice area is. So I know a lot of firms that use the system that I do, which is Lawmatics, which automatically, honestly, send these people a fee agreement right from the beginning. I'm not doing that because I'm divorce law and I don't necessarily want everybody as my client, but that's what some firms are doing, because there's a lot of competition in PI and a lot of competition in criminal. So getting those fee agreements out is really important, because I guess you can kind of unwind that later. If they sign the fee agreement and then they talk to the client and they decide it's not a good case, I guess you can just decline them at that point. But that's just something to think about in terms of what your actual practice area is. And if they don't get an email response, they're going to call. They're just going to. So your ideal intake process can help you attract your ideal client. I firmly believe that. So this is, I love this. It is so indicative of family law. So I definitely want to represent the husband in this case and not the wife, because I like to have an easy life. So I kind of design my process to make sure that I'm not getting the wife. And I get people that call all the time, like, I want you to make sure that he burns in hell. Probably not the right attorney for you. So we kind of screen those people out at the beginning, using our system and kind of, I want to use the word get rid of, but refer them elsewhere, because I know the client that I want the reasonable client that has reasonable expectations. And honestly, at this point in my career, for any amount of money, I don't want the lady that wants her husband thrown into a vat of lava. I just can't do it anymore. So these are a couple of short visual mapping of the intake. This is the very basic one. So for the ones where you're trying to remove all of the friction from the intake process, they fill out a form, a contact record goes into your CRM, a case file is automatically created, and you can send them a fee agreement at the same time. That's a very compressed timeline. I have 3 timelines here, and I do the middle one. I like to apply friction on purpose for reasons that I'll get into, but you can have a system that as soon as they enter their information, you can create a record and send them a case file. And I think I have a slide on this later, but there's kind of creative ways to get this information, as opposed to just saying, hey, what's your name and your injury? You can do a poll. You can invite them to answer a poll. You can, I know that's the sales term for it, but you can have like a PDF or like a mini book that's about your particular area. And obviously if you capture their information, then, they're going to get the whatever freebie that you're getting. So that's another way to capture their information and get stuff to them right away. So this is kind of the process that I use. I have it mapped out a little bit differently than this example, but I just wanted to give different visual maps in case the one that I created makes you crazy, which it might. So this applies a little bit of friction where my answering service is answering a lead magnet. Someone told me that's what it is. It's a lead magnet when you're saying, hey, there's a book, or, top 10 things not to do when you're getting divorced, something like that, where they're giving your information and giving that free resource. So this is kind of the intermediate intake that I do, where I have the answering service answering the questions, and then it's not really a long intake. I'll show you my intake form later, but it does give me a lot of information that I need in terms of, I need to know what county everybody lives in, because I don't practice in every county. So I need to know that from the beginning, because I have a one-click system to refer them to someone else. So if it's a county in a county that I don't practice in, I can click my referral source, and the client will get an email and a text with that person's information, and the referral service will get an email and a text with the information for the client and sending that person to them. And it doesn't take any time at all. It's just a one click. It's fabulous. So then in my process, after the initial intake is done by the answering service, I will go through it and I'll decline a bunch of people, or I'll refer them out, or if it sounds like a good lead, then I'll put them in the next funnel, and I'll show you my funnels later. And once it gets into that funnel, then someone from my office will call back. So out of the 15 to 30 calls per day, we're probably only calling back 6 or 7. So I have eliminated the others by declining them or referring them out, or whatever I need to do. But it just really limits the amount of time on the phone with what I know is honestly a dead end case. So once we schedule them, they automatically get reminders. This has their conflict check happening after the appointment, which I think is crazy, and I didn't know how to fix this, so whatever. Mine happens earlier on. As soon as the contact is logged in the CRM, Lawmatics does an automatic conflict check, and we'll stop the workflow if it's a conflict. And from there, I can see if it's an actual conflict, or if it's a mistake, or if it's just someone with the same name, and then I can restart the workflow. But I think that should be done earlier than this chart suggests. So you have the consult, you send them the intake form, which should be automated as well. They sign electronically. At this point, everybody should be doing electronic signatures, and really no need to do paper ones, even if people are in office. And then the retainer payment is completed. We do that all online as well. Law pay is the only kind of payment that I accept, and of course should be given case. So I'm not going to go through this whole thing because it's a really long intake process that I don't do. But it might be helpful for other areas of law with follow-up. And I am sure that salespeople will tell me that what I do is wrong, which is I don't do follow-up. If someone calls and I have a meeting with them, I don't put them into a drip campaign. I don't send them emails saying, hey, remember that person you want a divorce? You still want to get a divorce? I just think it's weird in divorce law. People disagree with me. That's fine. I don't do it. With other areas of law, I think it's a little more natural, like estate planning, because no one's making it out of here alive. So everybody needs an estate plan. That's a little bit different than a divorce. No one needs a divorce. For some people might, but it's just not necessary, I think, like an estate plan. Or PI, if you're injured or you've been arrested for murder, yeah, you definitely need a lawyer. So you're going to pay for it, you get one for free. That's just a need versus a want. So I think for those sorts of areas, I think it lends more to these drip campaigns, because salespeople will tell you need like 7, 8, 9 touches, whatever, before some people decide to retain. That's probably true. I probably would care more if I didn't have as many calls coming in, but I do, so I don't care. So, but if you don't have a lot of calls coming in, then definitely you kind of need to do kind of a long drip campaign. But I'm not. So this is my intake process, which I'll blow up on the next screen, but this is how I did it, which is visualparadigm.com. And I probably copied someone else's template and then just added my stuff into it. But this is mine, and it looks crazy, but it works for my brain. But there's the pre-intake and the intake team, and then the post-intake. It just kind of maps out everything visually. So I kind of like to look at things visually. So I'm not going to go through it in detail because I did kind of explain my process. But in case someone new comes in, this is for them to look at and sort of see. And in terms of my sort of input in this process, it's not a lot. It's this step here where it says my name here, Regina on the side in the purple. That's kind of where I get involved. So if they meet the pre-qualifications, that's where I'm doing the things below. I'm sending the referral, I'm declining, I'm referring to the state bar, or I'm moving them over to the intake team. So that probably takes about 15 minutes of my day. And that's me screening about 30 potential client calls. So it is not a lot of time. From there, once the intake team puts the notes in, they probably talk to the client for about 15 minutes. I probably take about 15 seconds to review their notes. And I make a decision that quickly as to whether or not I want to move forward. So sometimes I decline people after that part as well. So Jessica has a question about the attorney-client relationship. Do you want to ask? Just ask it. You want to ask it in the chat, or do you want to ask it live?
Oh, I wanted to ask it live. Sorry, I just didn't want to interrupt.
Okay.
Because I'm setting up my intake process right now, actually, and so this has been on my mind a whole lot. And I'm also in Georgia. So, how do you balance the intake process with when you actually establish the attorney-client relationship, especially if I'm the one answering the phone or I'm the one doing the, 15-minute just screening call just to, touch base with them. I do intellectual property, mainly copyright. So
Okay,
it's a very different vibe,
right.
but I'm kind of deal with just volume on this with clients. And so I know that if they say something in that conversation, it could preclude me from representing somebody in the future. Obviously if
Yep.
it's confidential information. So how do you just kind of balance like, getting a client, but then also not subjecting yourself, screwing yourself for the future if they think that you're in a relation. Anyways.
Well, that's
I would love to.
one of the reasons why I don't answer the phone, to be honest.
Yeah,
So,
I know.
because-
I'll get there one day, but right now I have to talk to everybody.
Right. So, I mean, you're gonna conflict yourself out of a lot of cases if you do it that way. That's just the nature of it. Because even if you're not charging for it, it's going to be considered a
Yeah.
consultation, and the client is going to remember speaking to you. Now, if someone called, because this happens all the time, not all the time, but it's happened a few times where, I've started a divorce case and the other attorney says, hey, my client says they had a consultation with you and you're conflicted out. And I'm like, nope, I can tell you exactly what happened. They called my office. They gave some general information, which I don't even read. And then they never went any further in the process. It's not a conflict for someone to talk to my intake person, because we're not getting super specific details. We're getting like, what county do you live in? And so that's not conflict. So that's kind of how I've dealt with it, by not answering the phone. And that's why we don't get too in the weeds with the initial screening. Because I don't want to conflict myself out, because there's people intentionally trying to conflict people out, especially in divorce laws, by calling everybody and having consultation. So,
Dang, I've never heard of that. That's
oh my goodness. Oh, that's 100% a thing in divorce where, I mean, it doesn't work. There's so many divorce attorneys, it ends up being stupid, but they'll go around to who they think are like the top 10, divorce attorneys and have consultations just to conflict their spouse out. But honestly, there's so many good divorce attorneys in Georgia, like you can't talk to everybody. So it's just dumb.
Yeah.
But that's why I charge too. Like, if I'm gonna get conflicted out of the case, I'm at least get paid $400 for it.
Right, exactly. I'm just in a really unique kind of situation. Okay, that's good. And then they do sign the client agreement, and that is when it officially begins, is when you decide, after you decide to take them on, that's when it starts.
Right, after the consultation, I mean, I'm conflicted out after the consultation, whether or not they hire me or not, but the client representation begins when they sign the fee agreement and they pay me.
Yeah, I think Jessica wants to respond to my question in the chat.
Is that
Yes,
okay?
Jessica
Can I jump on?
Matthews.
I don't have my camera on,
It's okay.
but you don't want to see me right now. So Jessica, I'm also an IP lawyer, and the way that I get around that is I do consultations, because for me, I just have a really high close rate when I talk to people. So it's a really effective way to get clients. But what I do is I have them, I use Calendly scheduling, and I create a questionnaire up front that gives me basic information about their company name, the goods and services that they offer, the owner's name, just basic stuff that would help me do a conflict check. And we always look at that before the scheduled call time. And then, and that way you don't ever, you make it clear in the questionnaire that no attorney-client relationship is created, that you will not be giving any free legal advice, and that they should not share anything with you that's confidential. And then we're able to look at the questionnaire ahead of time, do a conflict check. And so we will cancel consultation calls with anybody where there's a potential conflict. So that's for IP lawyers, that's a way around it.
Thank you.
Yeah, to go ahead and do the consultation.
Yeah, okay. But, yeah, I do an intake form and all that stuff already, and I didn't even think about doing the conflict check at that stage, but that makes so much sense. Thank you.
You're welcome.
So yeah, I use Calendly as well as Acuity, and we do use that to screen people out, because I'm starting to do estate planning as well. So I do have a questionnaire, and then they can self-schedule. I don't let divorced people self-schedule, because I need my team to talk to them to kind of gauge their demeanor and everything else, because they may have a good case, but they may just be crazy. Or just have unreasonable expectations. So I don't just accept any case because they need to get divorced and they have money. So we're screening for other things. So that's why I have my team call back. So in terms of looking for the software, there's a ton of them. I don't sign up with anything that requires a commitment. Like, this probably explains why I'm single, but I just don't I feel like you shouldn't sign up for something that says you're bound to me for 3 years or whatever. I feel like if you have a good product, your customers are going to stay with you for a long time, not because they feel shackled by a contract. So most of the CRMs don't really have a contract. I use Lawmatics. I have a list later. I forgave the other ones. I used to use Law Hustle. It was more expensive. I think it was just someone told me recently, which I didn't know until after that, that they're basically just a rebranded. I can't remember the name of the non-legal entity, but it was twice as expensive as Lawmatics. So that was kind of a no-brainer to switch. It should be very easy to use and monitor and be comprehensive. So I'll show you some of my slides for my my intake system later. Oh yeah, so these are some. Dubsado is not law connected. This is what I used before Lawmatics. The only reason I stopped using Dubsado is because at the time I stopped using it, they didn't have texting. I don't know if they do now, but in terms of all of the other automations that I do, they do that, and it is extremely inexpensive. Clio and Clio Grow is an option. MyCase or Spilevine, Lead Docket, Locus. There's a few of them, and you can look outside of legal in terms of CRMs. The CRM does not have to be, legal based. And a lot of these systems, honestly, are just non-legal with some legal stuff branded on it because they feel like attorneys will pay more for that, which is true, apparently. So use shareable embeddable forms. So the benefit of having a form like this is that when you change the form, the link doesn't change. So if you're deploying these forms all over the internet or in different areas, for example, I have them on my Google My Business page, I have them on my website, I have them on my digital card, they're in my email, so they're all over the place. So the link itself doesn't change, but you can make updates to the form and you don't have to go and post everything all over again. All right, so calendaring, we've already talked about a little bit. I also use ChatGPT for this. I said, what are the most common online schedulers? And I think this is pretty correct in terms of what most people are using. I'm using Calendly. I've not used Doodle, but I'm familiar with it. I've used Acuity Scheduling, Schedule Once, and Set More. I've not used other tools. They all pretty much work the same way. Some of them have free trials, so a lot of it just depends on which system that you want to use. But it definitely reduces the back and forth in the email tag. I personally do not send out my link for people to schedule, but it is helpful to have the link because then my team can they don't have to ask me when I'm available. I've already put my availability in the system and they just use the form as if they were the client to set up the appointment. But of course you can send it directly to the client and they can self-schedule. So this is an example of what you can put in a form. So this is just somebody else's example that they sent to me in terms of things that the clients can set up for and sign up for. And one thing I recommend, especially if you're in one of those areas of practice where, if you're not being responsible enough, they're going to hire someone else, is you need to give them homework. So I do in divorce and in custody by saying, if there's a case pending, I need to see all of your documents. Here's the upload link. So they're uploading documents, which gives me a chance to review them, sometimes even before the intake person calls them back. Sometimes, honestly, that screams people out because I read the filings and I'm like, well, you're on your 4th contempt order, so that's a no. Or sometimes it makes me want to take the case. So giving people homework and giving them something to do is going to help stave off their want to call someone else right away. If you don't get back to them for 2 to 3 days, like you're done anyway. But if they're getting homework and you're responding to them within, I think, 24 hours, I feel like that's good enough, or it's going to be good enough for me because that's what I'm doing. So these are just different ways to kind of put what your policies are in the scheduling. All right, so these are my intake forms. I have a short one and a long one. I use 2 answering services. I use Smith and I use back office Betty's. So Smith only let me have a smaller intake form. I mean, I could have a longer form, but they were going to charge me for it, but I didn't want to pay. So my second one is back office ready. So this is the short one, and this is the information that I really, really need that helps me straighten stuff out. I am currently not doing any custody cases. I'm tired. So I'm referring all of those out. So I definitely have in there, do you have kids on the other side? I put what county you live in, because that depends on where the case is going to be filed and whether I'm going to want to handle it. Is there a case in progress? The cases in progress, honestly, are my favorite inquiries to get, because it shuts down a lot of the unknowns. I know where it's filed. Most times I know who the opposing counsel is. I know who the judge is. Because a lot of times the opposing counsel and judge will disqualify me or me wanting to do a case. So I do like to have all that information. So honestly, those are my favorite inquiries to get, where there's a case in progress. And also means there's a little more of a sense of urgency from the client, because they know they need an attorney because they've already been sued, as opposed to if they just think they want a divorce, but they really don't want to pay the other side alimony, they know it's coming, they'll kick that can down the road forever. I also ask what county is it filed in if there's a case in progress. I feel like this is a good question to ask, because otherwise I'm going to get a lot of pro bono calls. So I say, how do you plan to pay? I'm just upfront about it. Check, credit card, borrow from family, friends, bank, borrow from retirement funds. I need information about financing. I used to have, I don't know. I guess I took, I don't know out of it. But I guess I'm forcing them to sort of pick an option. But that answer, quite frankly, can be very helpful in me screening a case. And is there a potential that the other party can reach a full agreement on any issues? So sometimes I'll get responses like, I think we'll agree on some, or I'll get, nope, this is going to be a knockdown, drag out war. And honestly, sometimes that makes me not want to take a case. And then this is the question I have about tech. In order to provide fair flat fee, oh gosh, there's an error in there. That's been up there forever. Flat fee billing, it should say Edwards Family Law is a paperless firm. You must be comfortable with email, scanning, and use of the client portal in order to be a client. Is that okay? And I'm totally fine if they say no. If they say no, I'll refer them to someone else that may be willing to work with them. Or I'll refer them to the Atlanta bar, but I usually don't proceed past that point, because that's just, I just can't. I can't deliver my services the way that I want to if they can't use email and all that stuff. All right, let me go back and look at some of the questions. Jonathan, you can try to ask me a question about lockets, but I used it not very long, basically just through the trial period. But there is a webinar about lockets on the group's YouTube channel, because I think it's Nicole Laughlin. I think it might be Nicole Laughlin, the state planner, that uses it, but there's like a whole hour-long webinar on my page.
Okay, yeah, I was gonna ask mostly just what made you switch from. I'm working with a consulting client who is planning to transition their firm to Locus, and I haven't worked with that software yet. And so I was asking if there were any pitfalls I should look for to kind of let them know.
I liked Locus. If anyone has followed me for any length of time, you'll know that I'm not a fan of Clio for a bunch of reasons. Not that it can't do what it says it's going to do. I just feel like they should do more for the price. And there's this whole other issue of, gathering their clients' data to sell them stuff that they don't need. But I like Locus because it's newer in this space. It's a little more streamlined. It's easier to use. I think the reason why I did not want to use it is because there was really no easy way to import stuff into it. I really can't remember why I didn't want to use it, but for someone that has not used a practice management software before and they're starting from scratch, I think it is a viable option. But the webinar that's on the channel really goes into details about the automations. Like I think I say in that webinar, it blew my mind, and it's hard to blow my mind when it comes to tech and automation, and what she was doing, it was incredible. So I think there's a lot of good stuff there. I just can't give a ton of specifics because I didn't use it long enough.
Okay, and what did you say the name of the person was?
I don't remember. It's on my YouTube channel, so look it up.
Okay, I'll just jump to your YouTube channel.
Yeah, the YouTube channel is Lawyer on the Beach, and then it's called Locus Webinar. So I think it's Nicole Laughlin. I think so. I don't know. You'll find out. Yeah. So Mike asked suggestions on which case management software would work best with Google Docs. So my case isn't compatible. Yeah, I'm not a big fan of my case for a bunch of reasons. I know people love it and they swear by it. I don't like it. I have used Practice Panther. I do know that they integrate with Google Docs. And I guess it just depends on how you want it to integrate with Google Docs, because I think a lot of them can be with Zapier. Everyone knows usually that my case has a closed API, so it's hard to get stuff to integrate even with Zapier. So I usually recommend using a practice management system that has an open API, because usually you can just kind of MacGyver that sucker together with Zapier. The reason I don't use a practice management system is I feel like I shouldn't have to MacGyver stuff together. Like, it should give me everything that I need. And I have not found a practice management system that does everything that I need. So I just don't use one. And I use a project management system, which is money.com, to handle my internal tasks. And I just kind of use other little things separately. Like, I have a portal that's separate. I have a document sharing system that's separate. My CRM, which is Lawmatics, that's separate. And that way, if one of those things I decide I don't like anymore, I can just switch out that one thing instead of trying to overhaul the whole thing. Someone asked what financing options I provide, whatever LawPay does. So when you go to LawPay, the third tab says financing, and if they qualify through them, you, meaning the lawyer, gets the money up front, and they pay, I think it's through a firm, and they pay a firm on a monthly basis. So that's it. That's all I do. I don't do anything else. I think I've had 2 clients use it in the past year. Other than that, I just tell them they have to pay me up front. So anyway, so these are my forms. Obviously, your forms don't have to look like this, but you've probably done intake long enough to figure out what are your pain points and what are the things that you really wish you had known at the beginning, so you don't waste your time, and put that in the intake form. So yeah, my script is in here, which I'm not going to go through the whole thing, but you can click on the link once you download this PowerPoint and get my script, but it's long. It's really long. And I think this is only a couple of the pages. So you can see here that they can decline this stuff from the beginning and without having to ask me. And these are all the things that I do handle. I only handle, for example, child support. When the person who's calling is owed money, I don't represent people that are behind child support. I don't feel like it. And it just always frustrates me when someone owes like $2,500 in arrears and they want to pay a lawyer $2,000 to avoid paying money that they know that they owe. Anyway, I don't do it. So the answering service gets rid of those people in the beginning. So next up, so these are just one of my automations. I don't use Sensado anymore, but it's the same process in Lawmatics. So this is just a really short follow-up with a very warm lead. And I actually don't have this active anymore, but this is what I was doing in the beginning. So the initial email, which I'll show you in a minute, goes out, and then a follow-up email with, the recommendations from prior clients. And then there's one 3 days later that has, a link to my YouTube channel, not this one, but the one from my firm, that has different videos that correspond to the kind of case that you're calling about. I usually don't deploy this, but you can. So this is a sample confirmation email after I just did a talk at ABA Tech Show, and this was my co-presenter's confirmation email. She's a debt strategy attorney. So this is her confirmation email after someone sets an appointment with her. This is my second email in that flow, which is the one that has the client testimonials. Obviously, since I'm using the first initial and last name, I got my client's permission to put this in an email. Obviously, get your client's permission if you're using anything that can identify them. So I did get them permission. I also have, probably gonna take out the whole COVID thing. I put an email about me, things about my firm, and then things about me personally. So this is, I guess this is just a written form of what my intake is. We can skip over that. This is my invitation for someone to do a 20-minute discovery call. This is very rare where sometimes it's a referral, maybe from an attorney, and the person is maybe high profile, or I don't know. There's just going to be some people that that you're going to want to have a consultation with. So I have an automation where it's just one click. I can invite them to call, and this is what they get. They can send us documents. There's the video links. If it's a custody case, then these are the videos they're going to get, and then they can schedule themselves for a 20-minute discovery call with me as well. Oh, that's a duplicate. So I'm gonna delete this slide. So this you're probably not gonna be able to read, but that's fine. So the point of this is not really to show you anything other than those are all the different emails that I have. So it's a lot. I've seen different people's Lawmatics build outs, and they have hundreds and hundreds and hundreds of proposed emails. So it can be as complicated or as simple as you want it to be. But the point is, it does take a while to set up, but once you get this set up and it runs like clockwork, you have all of these options. And it really does kind of feel, even though they're canned emails, clients don't respond to them like they're canned emails. I mean, they'll respond saying, thank you very much. I look forward to talking with you, all those things. So it's a way for it to be canned. So you're not taking a lot of time, but it doesn't sound canned. So I think this is just an example of texts and emails you can send to help keep the client engaged in the process until the time that you get to speak with them. So it's just another example. This is, you can consider an alternative form like I was talking about earlier. So for example, hey, estimate what your traffic ticket is going to request, or what to do in an eviction, or you can do a checklist, or you can do a quiz. Other industries honestly do this pretty well. I am so easy to sell to on like Facebook and Instagram. I have to stay off of it because they'll put little checklists or quizzes, and next thing I know, I'm being sold something. So there's a way to kind of not make it look like a contact information grab, which is exactly what it is, but to give the client value for that, and you get their information. This is somebody's landlord intake, so it's got a lot of information. I think, most salespeople would tell you for the initial intake, it can't be this long because no one's going to fill this out. This is really long. So I would think this is kind of at the second pass where you're getting more information, but the initial to kind of get them in your system, you can do that. And then you can send them this intake form after that. But the initial form probably has to be pretty short, because me as a consumer, if I see the initial contact form, it's this long, I'm not going to respond to it, but I will if I know a consultation is coming up. This is the canned email that I send from Lawmatics, that basically just gives the email about my firm. It looks pretty, and I look pretty because I was a photo shoot before COVID. But it actually looks really nice, and looks this way in text and in email. So that's one thing I do like about Lawmatics, is that it just honestly looks pretty nice. So I'll just show you a couple of my screenshots. This is the funnels. These are the funnels that I use. And there's, I think, a couple missing on the end. I think one is hired, and there's something else I don't remember. But these are the most important ones. Anytime a client calls, they go into the first funnel on the left, and that's where I'm screening them out. So I'm just clicking on them and hitting refer to person A, refer to person B, decline, refer to Atlanta Bar, or I just drag them over to the green funnel, which is, it stands for Krista and Morgan, my in-house people to call back. So those are the people that they call back. Once they call back, they go into the purple funnel to the left, which is showing that they've called. And I don't do anything with it after that. I just let people just sit in these funnels until they wither and die, I guess. So if a consult is scheduled, that goes into that column. If the consult is held, I put it in that column. And then if I send them a fee agreement, then it goes into that funnel as well. And then if I decline a case, or the client declines, and then go into the archive funnel. And then I also have a referred out funnel, which is really, really long. Of all the cases, you can see 548 cases. This screenshot, I think, is only about, I want to say like less than 9 months of cases. So you can see how many people are in each funnel. It's a lot. So, and you don't see the hired column, and there's another one, but so 548 cases I've referred to other attorneys. And if I had to do that in any way other than a one click, that would have taken forever. This is a shot of what the system looks like. This is a file that I created for myself, and I just texted myself so you can see how it works. But the activity timeline shows every single thing that has happened on that contact. And then if I want to schedule an appointment, you can see the buttons there for that: schedule an appointment, request an appointment, add a task, log in activity, send an email, chat. And then of course you can go to billing, files, tasks. Lawmatics is now expanding into the practice management space, slowly. It's not great yet. Their tasks are better than what they were, but they still have a while to go. So it'll be a while before I decide to switch and use it as my only tool. But a lot of people are using it as their only tool because now they have billing, they got trust accounting and flat fee accounting as well. This is just further down on the activity list of all the things that we did. One thing I like about Lawmatics is that it is white labeled. So when I'm sending them emails through the portal, it's showing up with my firm on it as opposed to there's no Lawmatics branding on it. These are the workflows that I talked about. And as you can see, I've had 1,600 initial initial calls. This is probably less than a year when I started using this. But that's just how many. It just shows how many of that particular workflow has deployed. And then these are some of the other ones. So in terms of building out the automations, I did get a little bit of help with that. They're not terribly difficult, but it does take a little bit while to set up. So Jessica's asking, what types of communications are you texting clients? So the initial text that goes out, I believe I put up here. Yeah, so we pretty much say, hey, it's me, Edwards Family Law, the flat fee. I always put that because honestly, that's one of the things that makes us stand apart from most family law firms. If we can help, our intake team will call you. If we can't help, we'll email and text you. And if you have a modification case or a case of contempt, I need to see your previous documents and you can see this is my upload link. And it's normally I would just have upload here and a button. That's what it looks like in the email, but in the text, you can't really do that. So you just have the link, but everything's clickable. So that's the initial text that I send. And then for the referrals, I'm sending a text to the client saying, hey, I can't take your case. This person can help you. I have simultaneously given them your information. And again, that's just done with one click. I've already set up the emails. I've already sent out the text messages. So this is the email that they get as well. So as you can see, this is a link where they send us documents and they click on that link. That's the email. This is the fee agreement, super easy to fill out. The only thing that I have to fill out is under roles. I just have to pick my name and that's it. Everything else automatically promulgates with the information that I put on the main screen, which is the initial flat fee, the mediation fee. I have different sections for that and I put the information there. So when I go to send the document, all I have to do is add my name and then it goes to the client. So basically the recap for intake is make sure that the initial contact kicks off a workflow and be able to send a fee agreement with just a few clicks, because if it's any more complicated than that, you're not going to do it right away and the client's going to call someone else. You use it, set up a drip campaign to follow up with tire kickers if you want to. I don't. I just let them find their way back to me if you want to. And you can transition potential clients into your current client system as well. And I just kind of have some other tips. All money isn't good money. Most people didn't practice more than 30 seconds to figure that out. That, a lot of times the client that pays a lot of money that's a pain in the behind is absolutely not worth it. And I firmly believe in the 80-20 rule, and I try to minimize that as much as possible. So the 80-20 can be applied to a lot of things, but at some point I realized I was spending 80% of my time on the 20% of the problem clients, and it was not okay. And I actually had a client call me out on it, basically said, I don't feel like I'm getting your full attention. And I know that the squeaky wheel gets the grease, but it doesn't, I feel like there should be more communication. And he was absolutely right, because I was too busy playing whack-a-mole with the crazy people. I didn't have time to really nurture the clients that, were really good clients. And at that, I went on a firing spree. I got rid of all the problem clients. And since then, I feel like I've kind of avoided the 80-20 rule, and that most of my clients are really, really good clients, and I'm not ending up with a bunch of craziness. So. Ooh, that's the end of part one. Are there any questions so far? Nope. All right, I'm gonna keep sailing along. The next section isn't that long. So
there was a question.
What was it?
Somebody else asked it, but I'm interested in the answer as well. It was how are potential new clients using portal for communication if they're not a client yet?
Oh, so it's funny you mentioned that, because a client said to me today, like, I don't know what you mean by the portal. I probably shouldn't call it a portal because honestly, it doesn't look like a portal from my end. I'm referring to Lawmatics. So I probably need to call it something different because it doesn't
Is
look
there-
like a portal.
Do you activate it for people that aren't officially clients yet though, or you do
No,
it for?
I have a totally different system for that. That's claims, and I'll show you that part later. So
Oh, okay.
I'm talking about Lawmatic. So when I'm texting them and emailing them, it looks like a portal to me, but it doesn't look like a portal to the client. And I didn't even think about that until this guy earlier today was like, how do I use the portal? I'm kind of like, you already are. But I need to come up with another word for it. All right, so part 2 is
I had a
communication
quick question,
through
actually.
automation. Sure.
So it goes back to your fee agreement and the process with that. One of the things that I've been trying to, I guess, get a better handle of is limiting the scope of what the services are that I'm offering for a particular client. So I've been getting bogged down in changing what that scope is within my fee agreement far too often. So it might take me like 25, 35 minutes to make sure that the client has the understanding of exactly what I'll be offering. So can you kind of touch on that, how you kind of eliminate having to do that?
Yes. So what area are you in? Practice area?
Yeah, so I do entertainment and sports on like business transactions.
Okay. So what I would suggest is coming up with your most common combinations, which I don't know what that would be. And I do separate fee agreements for almost everything, which is why I have so many. So I have one for TPOs, which is a restraining order. I have one for limited fee agreements, which is I'm representing the client through from the beginning of the case through mediation. I have another one for a network that I'm in, an amicable divorce network. So the answer to your question is more fee agreements.
Yeah, okay, got
More
you.
cowbell. So
Yeah.
it's a pain in the butt in the beginning, but once you get it set up, it's great because you just pick the one that you want. And as long as you title it correctly, like this is a business agreement for, I don't know, NFL players or, whatever it is, at that point, it's super easy to automate. But yeah, it may take a little bit of work in the beginning. Some people have a different way of doing it. They just kind of have a catch-all one fee agreement. And as you are setting it up, you just check the things that apply to that client. I personally don't want to do it that way.
Yeah,
I don't want to do it that way. So the answer is you have a whole bunch of different agreements that cover, and every single time you come up with a new combination, make it a template right then and don't wait, because the next time it comes up, you're going to wish you had made it a template.
yeah, I agree. All right, cool. Thank you for that.
Sure. So this is part about client communication through automation. These are all the ways to kind of automate some stuff and automate communication. This is my digital business card, just kind of shows you what it looks like. It cycles through those pictures and it's got videos, and then they can follow me on my social media websites. But that's kind of what if you want to see what it looks like, that's the URL above is vbiz.com/Regina. So I think digital business cards are definitely the way to go. I'm not handing out personal cards anymore because this is pretty easy enough, I think, to remember. And once you get to that page, you can automatically enter my contact information in your phone. And you can also contact me from there. And I have a special intake form just for this, so I know how many intake forms I'm getting from my digital business card. So I talk about a communication policy a lot, and that's mostly because people think I'm absolutely insane for doing flat fees and family law litigation, which I'm probably insane, but for different reasons. But it's possible, but you have to get a communication policy and need to stick to it. So this is my policy, which is we don't accept phone calls. I don't even have a phone in my office, so it makes it really easy. We just don't. And, it doesn't really matter who's calling. If Oprah's calling to get a prenup, she's going to get the answering service and she's going to call back from the intake person like everybody else. It just helps. And people always want to know, well, how do you convince your clients that this is the way to go? And the answer is not to say, make them feel that their call is the interruption. You have to reverse it and say, when I'm doing deep work on your case, when I am preparing for your mediation and for your trial, I don't want to be interrupted. And it's actually not a lie. I'm not lying when I say this. I don't want to be interrupted when I'm preparing for something. So when I'm working on your case, you don't want me to be interrupted by someone's phone call. So that's why we have this policy, is so that when I'm, dedicating the time that I've set aside for your case, that's the only thing that I'm doing. So that's how you sell it. So this is my communication policy. It's in the client guide that they get. They have to agree in the fee agreement to it, because I think it's easier to get them to agree at the outset versus you spring it on them later on. And I think honestly, this goes back to the intake. And I think a lot of attorneys that are jumping on the phone at intake are setting themselves up for a problem later on because the client is going to expect that. This on probably a side note, but it's honestly why I don't show up like for a first date looking my absolute best. Because honestly, you're gonna get let down later on. So I feel like it's important to kind of set the expectations from the beginning. So if you're not going to show up this way all the time, then don't show up that way in the beginning. If you're not going to drop what you're doing and answer a client's call, if you're going to do that, that's fine. You just got to keep that energy throughout the case. And I'm not going to do that. So that's why I kind of try to set the tone from the beginning that this is kind of how things work. Otherwise, the client unreasonably is going to expect something differently. And sometimes they feel like it's a bait and switch. If you're super responsive when you're trying to get their money, and then you're not as responsive after you get the case, you're going to have some client control problems later on. So that's why we try to keep it the same throughout the entire process. So we define what emergencies are. And I tell people all the time, like, if there's an emergency, call 911. Like, I'm not Wonder Woman. Like, I don't, there's like literally not much I can do. So I have to define what emergencies are. And honestly, in divorce, there really aren't emergencies, but the kind of emergencies I define, like your husband decided to take his kids to his mom's house in Tennessee for the weekend and you didn't want him to. That's not an emergency. It's not. So I tell people, this is what an emergency is. This is what is something that is very important and I care about, but I'm going to care about Monday through Friday during work hours. So honestly, since I've had this policy, it's been very helpful. So Keisha's asking, do I manually turn on a weekend auto reply every Friday? Yes, and you're about to see that email in a second. And the language in your fee agreements to agree, it's very simple. It just says, it has the link to the communication policy. It says, I certify that I have read the communication policy and I agree to it. And I have an initial next to it as well. So obviously your communication policy may be different, but my advice is just to get one. So how do you deploy it? I have done all of the above. It's in my email signature. It's in my email response. It's in videos. You can put it in drip campaigns. It's in my fee agreement. It's in my firm guide. If you want to look at my firm guide, that's the URL for that, tinyurl.com/EFL guide. And the guide itself is in the fee agreement. It's on their portal. It's in my email signature. So by the time they become a client, they have had access to my communication policy and my guide like 10 different ways. So there's really almost no excuse for them not having read it. And then you can also, with text, with your CRM, you can include that link as well so they can kind of get an idea of what it's like to work with your firm. And I'm sure there's a whole bunch of other ways that I've not thought about yet, but that's what you can do it. So this is one of my email signatures. I don't think this has the link on it, but the next one does. So I like to communicate things in my email signature. For example, I check emails twice a day and not after hours on weekends. And we close Fridays at noon. I think those are two important things that the client needs to know. So that's in there. And then I have the button for them to upload documents. This is my current signature. So my client guide button is there. My click to pay online is there. What's in orange, I stole from someone else. I thought it was fantastic. We work remotely, different hours. We don't expect a response outside of your normal working hours and allow some time to respond to you. And then also I have a vacation coming up, which is April 4th to 14th. So I include that in my email signature as well. So nobody is surprised on April 4th when Regina does not answer your emails because I'm not going to. This is my auto reply on the weekends. We close Fridays at noon. You will respond to all messages on Monday. Have a great weekend. And I give the form for family law intake and the form for estate planning. They can still look at the guide, pay online, upload documents. And honestly, I do get a lot of responses over the weekend and people are not looking for me to respond back. So they are just putting stuff into my portal, which I'm going to look at Monday morning. So the next few slides are just a couple of screenshots from my guide if you haven't been there already. And I think the timeline is super helpful on the right. This kind of gives them an idea of how long the process is going to take. I usually can shrink that in half, but I would rather under promise and over deliver than the other way around. So this helps them know how long the process is going to take. And most of the times we sort of think that, and we kind of mention that as we're wrapping up the case, like, hey, we thought this case would take about 12 months. I'm very happy we were able to resolve it within 6 months. Here's a link to that Google review. All right, so this is another screenshot from my client guide, which also had my vacation dates on there. So again, clients aren't surprised. I have my text message policy, which is don't text me. And that's for when they actually become a client. So I just don't do text messages when they become a client. They have to use the portal. Phone call policy, we don't accept unscheduled phone calls. That's also in there as well. And then this is just another look at the timeline. I do like this page, which is do this and not that. I constantly am adding stuff to this. What's in red, I had to add because of something the client did like 2 weeks ago, where they decided it would be a good idea to send a nasty email to the other side and copy their attorney. And I could just visualize the other attorney like, I'm printing this out. Yeah, so don't do that. So there's always something that comes up. I'm constantly editing this guide, but the good thing about it is the link doesn't change. So I change something in the guide. The next time they click on it, then those changes are going to be there. This is just how I stopped accepting phone calls. It's in the fee agreement and they agree to it. We send them a portal. We don't have phones. We use DialPad. Our answering service answers. It's just not really been an issue. People have always asked, well, what happens if a judge calls? And I'm just like, it just doesn't matter. I just don't know a judge that called and just upset that I'm not there waiting for them to call. So it's usually better when they leave me a message because I'm not caught off guard. I can look at what I need to, so I can give them an intelligent, response to their question. And then sometimes it requires me to confer with my client. And that way I usually call back within, a few minutes or within a day saying, and giving them the information that they need. So I haven't had any complaints from the judge's office about the fact that they can't get me on the phone. Yeah. So, and someone asked, well, what if they're looking for you to be in court? And the answer is like, that doesn't happen. I'm in court when I'm supposed to be in court. So that's just not a thing for me. Okay. So the next thing I'm talking about is discovery, because I have a system that really streamlines the process and makes my life a million times easier, because this meme is like a snapshot of my life for the last 22 years, that people want to play dumb when they're getting divorced and they're genuinely very surprised that the other person wants to know how much money they make. Like that, for some reason, it just never occurred to them that their stay-at-home spouse of 25 years might want some alimony. So what I use is a product called Tech-ify. There's a very long video, not very long, but it's about an hour long that walks you through the entire process. You can go watch it if you want to. There's a link. But this on the right shows you how the discovery is delivered to me once it's inputted into the system, which is fantastic. So this should be video. Hopefully it plays. Yeah. So this is what it looks like from the firm side. So the first thing that you do is you put in their name, their email address, and these are the things that, and in this sample request, he's only asking for 3 different things. So the guy that created this, his name is Steve, and that's his email address, and he's super responsive. So if you have any questions, just email him. So you can send reminders every 3 days, every day if you want to, every 7 days. You can have it expire if you send a request, and then that's it. So the client will get an email, and this is from the client side, telling them what to upload. And it uploads into the section that you've assigned it. So that's what allows it to export into those nice fancy little folders that you see at the end. And then it tells them what they've done and what they haven't done. So it's a green check, you're good. If it's a red X, you're bad. So it sort of cuts down on the, you send the discovery, you ask the clients for all this information, they send you back like 3 pieces of paper, and they start screaming at you like, I don't know what else you want. This totally eliminates that because it's very clear about what they've turned over and what they haven't. And you can reject things. So if you've asked for something in a particular format and they've not done that, you can reject it. For example, he's saying photo ID is too blurry, resubmit. And then they will automatically get a message and then ask them to resubmit that document. So they're going to get an email that shows them that they've done 2 out of the 3 things that they need to do. This is what it looks like. It's super, super easy. So this has cut our discovery time in half a lot. And this is what it looks like when it's done. So each folder is what you've named it originally in their request. So when I get discovery requests from the other side, I just use, whatever their request is, and put it in that way, and then the client has to upload to that particular folder, and then it comes out this way. So it can export, I think right now, to Google Drive, to Dropbox, or you can export it as a zip file, which is normally what I do, because I don't use either of the other two. So it makes it super, super easy. Another thing that it's good for is some of your counties might have mandatory discovery, and in our counties we do. So this is a template essentially. So everyone in Fulton County has to do the same discovery. So instead of reinventing the wheel every single time, in this case, all I'd have to do is enter the client's name and their email and hit send, and they will get all of their requests because it's a template. So that makes it super, super easy to get to the client. This is just the rest of that template. And on the right is an example of a case that I have where they went through and filled out some things, but they were missing something. So we can very easily see what's missing and what's not missing. So anyway, it's a super great tool. I think it's like $29 a user per month. It's not very expensive, and I absolutely love it. Another thing that it does is you can have the view history, so you can see when your client looks at it every single time that they look at it. So I find that helpful sometimes when people say, well, I didn't know I had to do this, or I didn't know about the deadline. They're totally lying, because you can see where they looked at it and they just mentally checked out and didn't feel like doing it. And you can see here on the right where, the client uploaded the documents. Sometimes what I'll do is you can rename in the actual system. So when it downloads, it has the name that you want. But the best part about it is because it's all being uploaded into the correct folder, it's just a lot easier than when you get like 300 documents and they're not organized, and you not only do you have to rename them, but you have to sort them into the right places. So this at least cuts down on the sorting, and sometimes you will have to rename it, but like that's the least of my problems. And then this is what the result is. All right. All right, into part 2. Any questions?
Do you find a lot of miscompliance from your clients and putting stuff in the wrong place?
No, surprisingly, no. So I'll go back to the original, if you can see it. Oh, so you can see here, like, for example, the title, like over here on RPD3, the title is RPD3 W2 forms, etc. And then below, you can write a very detailed description of what exactly it is that you're looking for. So you can make it pretty dummy proof. So they're not just relying on the title, but they have that very descriptive box below to say exactly what they need. So for example, RPT 4's pay stubs, I need all your pay stubs from 2019 to present. It's hard to misinterpret that. So yes, clients definitely like to play dumb sometimes with discovery, but this is as easy as I think it can possibly get.
And then if you've got someone who says, I'm happy to scan stuff and send it, but I don't really know how, or I don't know what program you want me to use or what hardware you want me to use, do you have recommendations you make, or is that a disqualifier?
Well, if they know how to scan, then that's all they need. So this is the program that I provide to them. It's very easy. They get a link in their email. They just click on the link and it takes them to that first form that says, hey, this is the stuff that you have to upload. So if they know how to scan, they know how to drag and drop a file. And I used my mom as a guinea pig over the weekend because I know a lot of people say older people can't get it. Well, she's 72 and I sent her this and I sent her instructions to my portal and to log on, and she did it just fine. So to be honest, a lot of times in family law discovery or really any discovery, people know how to do it. They just don't want to do it. It has been my experience. So unless obviously they have some sort of medical issue or cognitive issue or something like that, which is not the most common thing. It's usually they just don't want to do it. But so this makes it very easy and excuse proof. And since we've started using the system, we've spent so much less time on discovery, which makes my life easier. All right, so part 3 is using tech to actually prepare the case. And this obviously is like my favorite thing that happened over COVID was the cat lawyer. And then I found this follow-up cartoon, which I thought was kind of funny. So in terms of using tech to prepare the case, you can figure out what you can automate. Client communication, which we've talked about already. We'll talk about sending or answering frequently asked questions through videos, and I use Zoom for that, and setting up workflows and automations. And then I'll show you some of the workflows that we do. So something that I do in addition to having, these workflows and all this tech is I give my clients sort of transparency into the process. So that way we're not just kind of going into our hiding hole and appearing and saying, hey, we're done. Sometimes people want to see how the sausage is made. And as long as it doesn't cost me any sort of, more time and effort, I'm happy to do it. So Karen's asking me how many people do I have on my team? I actually don't have that many. It's just me and my office manager, who really is just a paralegal, except I pay her a lot of money and gave her the title. And then I have a legal assistant. That's it. It's 3 of us. And my caseload, nobody asked, but it's about 40 to 45. That's pretty much the max that I can do. All right, so automation. So workflows is essentially just a task that you've applied automation to. That's it. So everybody has task lists. Most people do that, but essentially you're just adding automations to it, and that's what creates a workflow. So these are some examples of things that you can automate, some of the things that we've already talked about. So in terms of the client process communication, so I use the client guide. I think that's a good way to get information out to the client about the process. And think about the questions that you get over and over and over again. And shoot a short little video that's not full of legalese. It does not have to be fancy. The phone that you have, your camera that you have is perfectly fine. And answer the questions. And you can put them in an email drip campaign, or you can send them specifically to clients that asks, but having this video library of all of these little questions that come up is going to be helpful for you later on. So if someone asks you a question, you think it's something that's going to come up again, just take the time and shoot a quick video. I mean, I've had some people, shoot a video and just send it to me when I'm a consumer in some areas. And, I appreciated their time to answer the question, and then it helps create a video library for those questions later on. And then I'm not going to talk too much about marketing, but it can help for marketing purposes. So if you're creating videos for these questions, you can SEO the crap out of it and put it on YouTube, put it all over the place, and it helps with your marketing. So, and with not a lot of cost on the front end. So an example that I've given is how to fill out a financial affidavit, because that is definitely the question I get a lot. That is a screenshot with my face frozen in a weird position. This is the video. I'm not going to play the whole thing, but I'll just play some of it. But it's basically me just explaining how to fill it out. So it's not a long video, it's about 2 minutes, but it explains to the clients, because sometimes people want to know why. Why do I have to do this? It's so unfair. Because you just do. If you're in a family law case in Georgia, you have to fill out a family financial affidavit. I really wish they had one for divorcing people and they had a separate one for all other cases, because it's got stuff in here about assets, which aren't as relevant for a modification case or another type of family law case, but there's only one affidavit. So I explained that to him in the video, that you may not think it's relevant, but sometimes assets can be relevant, especially if it's an income producing asset. So this is why it has to be done, and this is how you do it. So this video is linked in our guide, it's in our portal. So, if they need assistance on filling out the financial affidavit, they can just refer to the video.
Question.
Yep.
With your automations, do you use, so for like your drafting, do you ever find yourself mass drafting like certain documents? And if so, if not, why do you no longer do that? Right?
Mass draft documents?
So like, for example, like certain motions and judgments and stuff like that, like, because I would think, because I'm working on this for like another client's drafting, like for like an uncontested divorce, pretty much like a whole set of documents that would go in from that single intake process. And so I'm curious if you've done that before, and if you had like a positive or negative experience with it, because I haven't started doing it yet, but it's something I've been thinking about.
I haven't. So, I mean, I've toyed with some of the document generation stuff, but to me, the juice isn't worth the squeeze. And that's just because family law is so specific that I find that it's not that helpful. So, I mean, I can do a doc generation, it's going to create some documents, but then I'm going to spend a whole bunch of time going through it to make sure that it's correct and the customization is there that it needs to be, that I decided it just wasn't worth it. So I just have regular templates, and then my paralegal goes in and, you know, puts in the customization, and we do it that way. So there is a way to do a lot more document generation. I just personally don't. I have, but I just, you know, it was just another cost that I was incurring, and I found that it wasn't saving me a whole bunch of time just because of how specific my divorce stuff tends to be, because there's just no one size fits all. So we just started the basic template, and then I just add all the personal stuff in there, and there's almost no way for me to have enough variables for me to make it make sense. So I personally don't do that, but if you're in a different practice area or that's not an issue for you, that's definitely a way to save money and time and be more efficient, is to have document generation software. But that's just one thing that I decided not to apply tech is the actual generating of the documents.
Okay, thank you.
Sure. So in connecting your automations, kind of go through this process. I kind of treated myself as a client going through this process in terms of, I signed myself as a client in Lawmatics. I, you know, sent myself the emails. I sent myself the fee agreement. I just took myself on the journey. And is this easy to do? I mean, you want to make it easy for people to pay you, because it just makes it easier for people to sign up if they don't have to go through a whole bunch of hoops. When you close the case, make sure you have a process set up to end the engagement and to ask for feedback. And then obviously Google reviews are a very good way to, you know, help your online profile and essentially free marketing. So we'll talk about, oh, why is this frozen? There it goes. This basically is kind of a soup of task list. So I use Monday.com, or I used to, as I still use it, but not for this purpose. So what this was my discovery board of all of my discovery that was pending in all of my cases. So I had about 10 different boards related to the actual practice management. And so if you're not using Google Sheets or Monday and you're using a different system, you can use this, in my case, or Clear or whatever, to kind of have a board that kind of captures everything sort of in one shot. I switched over to Google Sheets because one drawback of Monday is each column has to be the same in each board. So that meant I had to have a board for incoming discovery. I had to have a board for outcoming discovery. So I just decided to create a case plan document where I put all of that stuff into one document. And I'll show you what that looks like in a minute. These are some examples of automations that I can use in Monday. When I was using the discovery board, these are all of the things that sort of help move the tasks along. So if I had discovery becoming due, then my paralegal would get an automatic notification. 3 days before the other party's response are due to us, there'd be a notification. So obviously it's unlimited in terms of what you can do, but this just sort of helped us keep track of everything without having to do any extra work. Because once the automations are set, you don't have to do anything to them, they automatically deploy. This is a task list for prepping a trial with children. These are all the things that I have to do. And I'll show you later how I actually share this with the client now. I wasn't doing that before, but this is my checklist. So I just am in the philosophy where I like to use checklists versus task lists. So in all of the practice management systems, you can set up task lists, and a lot of people will tie it to a date. So if your trial is April 3rd, you're going to have all of these tasks assigned to a certain person to do by a certain date. That is one way to do it. I don't do it that way because honestly, I don't want to. So the reason I don't is because when I prepare for a trial, I honestly do it all in one shot. So I just sit down and I just go through and slaughter these tasks one by one, bam, 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 bam. And I just go through and sort of check them off. Anything that needs someone else to do, then that's why it says awaiting Krista, working on it, whatever. But I just do the whole checklist at once. And then the few things that are left over, they automatically get tasked to the person that needs to do it. And that's that. And we're usually doing it like 2 weeks before trial. So there's not really any kind of last minute stuff. But these are the automations that I had applied to the task list to kind of let someone know when something needs to be done. So that's what I was doing before, and this is what I'm doing now. So I have this case plan document, which it took me a really long time and months to create, and which is why I sell it on Etsy if anybody wants one. But the document itself is only $99, which is it's just this sort of overall case plan, which of course is editable for your particular practice area or whatever. But all the information I need to know about the case is here, and it has all the checklists. And because it's a Google sheet, I actually share it with the client. So the benefit of it is they can see things being done without me having to tell them things are being done, because they can just click and look at the sheet anytime they want to. So all the information that's relevant to the case is going to be on here, like the county, the judge, holding party info, the client info, kid's name, stuff about the kid that matters. I'm flat fees. I don't have a robust, I don't have to really keep track of payments or invoices or anything. So all I do is have to put in the flat fees there. And then the status has been very helpful to tell them what is the current status and what's coming up. So I do have a much longer video that explains how the sheet works. So I'm not going to get too much into it, but really the point is that the client gets to see all of that stuff. So as we're preparing, for example, for a temporary hearing, for mediation for a temporary hearing, these are all the things that I feel like I need to do in order to prepare. And then the client can see what exactly it is. And so this is just sort of the base checklist. And for each client, there's going to be something special in here. Like client definitely wants to have the 1979 Firebird, or, make sure a client gets Fluffy the cat or whatever. But I put all of this stuff in the checklist. So as I'm preparing for mediation, they can see all of their issues are being addressed. And as we're going through the mediation, I'll still refer to the sheet to make sure that we've addressed all of their issues. So we don't settle a case and have a client screaming at me because we forgot about her cat Fluffy. So that's why I like doing this, because it helps me with my workflow. But then it gives clients transparency into the process and input, which I think helps, especially in family law, because a lot of times they feel lost. They don't know what's going on. Sometimes they're like an emotional wreck anyway. So having it all spelled out in front of them, to me, has been pretty helpful. So I have a marital balance sheet as well, but it's in the same case plan document, and the client has access to it as well. So we fill it out, we let them look at it. The more sophisticated clients or tech savvy clients, sometimes we'll go in and edit it as we get close to mediation. Maybe some of the numbers have changed. Most times they don't. They're just happy knowing that I know what I'm doing. So they're just looking at it and they're not really doing anything with it. But as I'm preparing for mediation, we can go through and sort of play with the numbers. And again, that just kind of helps them visually see everything, because to me, a lot of times when you're at mediation, people are just throwing out numbers and no one's really trying to figure out what that looks like. And I like the marital balance sheet, because if someone gives me an offer, I want to know in dollars and cents down to the penny what that means for my client. Sometimes the offer is better than the other side even knows it is, because they haven't factored in something that I have. So I like having the sheet that I can edit on the fly, that the client can look at, so I can see, what, their offer is pretty good because they forgot about X, Y, and Z. And this is why I think this is a really good offer. And otherwise, if you're just kind of throwing numbers at them in the void, it's really hard for them to wrap their mind around. What is this? This is my exhibit sheet, which is colorful. I like colors. But it's also included in my case plan document. So I put in the exhibit, the type of exhibit it is. I just clicked on it so you can see all of the different things. And obviously this is completely customizable. The issue that the document relates to, and then I have a drop down of the most common objections. I'm family law, so I on here everything gets in, but occasionally I win an objection. So I'll put the other side's exhibits. I'll just kind of proactively kind of have the foundation of why I think it should get in, or I'll have the objection of why I think their exhibit should not go in. So I actually do an exhibit chart for my exhibits and for their exhibits, and I just have the drop down menu of everything. The client sees this as well. Any questions about that? No, great. All right, so the last part is, to me, the most fun part is the actual trial presentation. So this is this is Chat GBT as well, and I said, I can't remember what the input was, but how do you present a case virtually? So this was the answer to that, which I'm not going to go through it in detail, but I'll tell you some of the things that I do. Because I'm doing this for my Gwinnett Bar Association, I am including some other things about just preparing the case for the hearing. I'm a big proponent of drafting proposed orders. I don't expect the judge to take my order and sign it, but having the order there keeps me on track, because in family law, we will often go down rabbit holes. We'll forget why we're there or forget something that's very important. So that's why I like to have a proposed order, because it keeps me on track. It keeps the client on track. And that way the client approves it ahead of time. So all of the things that the client wants, we know are at least in front of a judge. Doesn't mean we're going to get everything that we asked for, but we have at least asked for Fluffy the cat because it's in our proposed order. So nothing is left off of the table. So that has really helped us in terms of, client satisfaction, because, obviously I don't win every case, but if you have a family law case, which is highly emotional anyway, and you lose, and there's some exhibit that got left out, which usually doesn't matter, but that's not what the client thinks. They think it's the one thing that would have totally, turned the tide of the case. Just kind of having this sort of organization ahead of time sort of eliminates all of that. I stopped printing exhibits for my opposing counsel. They want to kill trees, they can do it. So I send all the exhibits to them ahead of time with the numbers on it. And I say, if you want to print, have at it. I'm not doing it for you. So, and I don't print one for the court reporter either. So now I'm only bringing one copy of my exhibits, and that's for the judge. And we have screens in our courtrooms, or we can show the exhibits on the screen. So the other attorney can look at it that way, or they could have printed it at their office. I don't know. I don't care. It's not my problem. But I just don't print extra copies anymore because I think it's a complete waste of paper. This is just more about preparing my clients. I'll just kind of skip over that, but definitely give them the proposed orders ahead of time. I say Fluffy a lot because that actually is a true story. I had a case where I got a client like a whole bunch of money in alimony, which I don't think she really deserved. But as we were walking out of the courtroom, she mentioned her dog for the very first time. Like, what about, I don't remember his name, it was like Jabbert or something, just completely ridiculous. And she had never mentioned it before. Thankfully, the other dog hated, her husband hated the dog as much as he hated her, and he wanted them both out of the house. So he was fine giving her the dog. But I just kind of use it as a reminder of, when I have the proposed orders and the checklist and I go over it with my client, that sort of, just reminds me that every single thing that the client wants is at least on the sheet for the judge to consider. So I'm not missing anything. So. And this is just more stuff about how, if you're doing a trial by Zoom, doing test runs. I mean, we are 3 years into the sucker, and I am still surprised when I am doing trials with attorneys who I know have been paid a lot of money, and their client is lying in the bed, or you can't see them. They look like they're in the witness protection program. We should know how to do this by now. But in general, I do tell people, do a test run. I do my trial preps by Zoom anyway, so I'm able to kind of test and see what their setup is ahead of time, just to make sure that they present well in front of a judge. Yeah, I just think it's helpful because a lot of times appearances are everything. These are just more tips about trial presentation. I always use more than one monitor. I have 4 right now, and it is helpful when you're presenting because you can have a presentation on one screen and your notes on another, and everything's not crowded on one screen. The proposed orders, I do present virtually as well. I put them on the screen. I think judges appreciate the visual aid instead of you just talking at them and them taking notes. So when I give them the proposed orders, sometimes they'll write on the proposed orders their own notes, and I leave plenty of space in between. So the ones that actually like to write, that's fine. I give them something to write on, but I think it's helpful for them to have just sort of a checklist of what it is that I'm seeking, and then they can put their own notes like, yes, no, this is crazy, whatever. But at least we've asked for everything. So this is some tips about Zoom trial prep. Get an external microphone. Your external microphone is always going to sound better than the one that comes with your computer. Get an external light. I have this really bright light in front of me. If I turn this off, I promise you I'm going to look like Gollum. It's actually a photography light. So I've used a ring light before, But when I wear my glasses, it actually reflects in my glasses. So this is a photography light. When I got my makeup done once, she had it and I immediately got it. And I think anyway, it makes me look good, I think. So make sure you have a light and it's facing towards you. Otherwise, you're going to be backlit and you're going to look terrible. When I was meeting people in person and I was doing Zoom from my office and my client was there, I printed the exhibits. This is actually a picture from the first Zoom trial that I did in 2020. And you can see I have the exhibits printed there in front of the client, so he wouldn't have to be on top of me because it was the middle of COVID. And knock on wood, I'm probably like the only person who's not gotten COVID, and I'm going to keep it that way. So these are more setup tips. And then these are my different screens that I use. And this is actually, I was on a trip, I was in Florida, so I actually brought the portable monitor, which is very portable, and the big screen, which is not as portable, but I still like to have a bunch of extra screens. But when I go to trial in court, I usually have 2 or 3, and it's the portable monitor screens. But it all fits inside my laptop bag, so it doesn't, I don't think it looks that excessive. Oh, that is a duplicate, so delete it. And I always have to tell people, if you don't know how to try a case, like, being on Zoom or in person isn't going to help. So you still have to, the foundational principles still apply. That doesn't change. The only thing that you're changing is how you're presenting the exhibit. So instead of walking over to opposing counsel, instead of, walking up to the witness stand, you're showing it digitally, but it's still the same process. So I feel like for some reason, some of my trials, people think that everything goes because it's on Zoom, and that is absolutely not the case. One thing I do to prepare the case for hearing, we talked about proposed orders, but I do pre-number the exhibits and send with the exhibit list. So some people wait until they're in their trial and then they put them in order. They start with 1, and anytime they put an exhibit, they go 1, 2, 3, 4. I don't do that. I pre-number everything. If it gets out of order, if I skip some and some don't get in, I don't give a crap. I've just decided, because I cannot keep track if I'm having to number them on the fly. The other benefit is some of our judges want us to send the exhibits ahead of time and they print them out. So having the exhibit number and the page number on the actual document helps their staff when they're printing them out, because if they go to the printer, there's a whole bunch of crap on there. It makes it easier for them to sort it out when it says plaintiff's exhibit 1, page 1, page 2, page 3. And it makes it easier for opposing counsel too. So I pre-number all of my exhibits. I pre-page number all of them. I send them to the judge after the hearing. I send them to the court reporter. I do all of that electronically, so I don't have to do any paper. One of my advice on pre-numbered exhibits are to be very, very specific. So as you can see, this is a pretty specific name of exhibit. So this came from an actual trial. I redacted all of their names. But the benefit of this is if the court has to go back and look at exhibits later and they want to look at a particular email, if you have 50 different documents called Exhibit 1 email between parties, they're going to have to look at all of them to figure out exactly what they're looking for. So I'm very, very specific about what the titles of my exhibits are. I've actually had objections to the titles of my exhibits, which isn't a thing, but I like for it to be specific. So in case the judge needs to look for it later, or I need to find something later, it just makes it a lot easier for me. This explains how to put footers on PDFs, but I think everybody's figured that out by now. I did part of this presentation a while ago. So communicating with text with the client during the hearing, you can use a text. Sometimes I use my portal. Sometimes I open a shared Google Doc. Obviously, this is not during your client's testimony to coach them through it. But for example, if the other party is testifying and if they have questions, they can't jot it down on a piece of paper like we did in regular trial. Or if the client is making facial expressions during the other person's testimony, I can no longer pick them in the shins. So we just use a shared Google Doc to communicate with them right away, Hangout, Slack, etc., or ask for a brief recess if you need to. So sometimes people forget about that when you're in Zoom trial. You're not stuck there forever, you can leave. So I'll talk about this only briefly because this is pretty specific to my county. This is what my county uses. It's called ClickShare. In order to share our documents on the screen. It's just a simple dongle that goes into your computer and then it displays it on the screen. So there's a video that accompanies it, but I will skip it because that is very specific for my county. PowerPoint. So I am a big PowerPoint fan. You know, a lot of people use Google Slides or Slide Deck or something else, but I like visual stuff. And for some reason in family law, it's not that common to have visual stuff. You know, a lot of business attorneys are doing it, a lot of corporate attorneys, a lot of civil litigators, but not a lot of family law litigators. And I found it to be incredibly helpful. So I wish my presentation mode works because this comes in one at a time. I'm afraid of it freezing again. But anyway, these came in one at a time. So this was an opening statement of this case that I had where I was defending a contempt, which I had absolutely no basis. So this sort of came in one at a time. So as I talked about each aspect of my opening statement, then it would pop up on the screen. And this entire case really rested on this provision in the settlement agreement. So I made sure to highlight it to focus the court's attention on that issue. I also like to use title cards. So during my cross-examination and my direct examination, I kind of like to let everybody, including myself, know what's coming up. So there were several issues in this contempt, and this kind of lets everybody know. Now we're going to shift and we're going to talk about the medical expenses. So the great thing about this exhibit is I kind of got everything on one screen, and I did it this way on purpose, even though the point is not that you could really read everything individually, but to show a pattern. He was being accused of not paying medical expenses on time, and I highlighted all of the green where he was paying on time, and she was just lying about him not paying. And then the one time that he actually did not pay on time, then I highlighted that in red, and I had, you know, an example. But the point of this is visually, it's just kind of appealing to show this is all of the green. These are all the things my client is doing correctly versus the red. And this ended up being a frivolous case. So that was just kind of a nice, I think, sort of presentation to have. This is another title card that I have. There was another child support issue where he was being accused of not paying child support on time. I could get 4 receipts on one page showing that he actually was paying on time. He was supposed to be on the 1st and 15th, he was paying on the 1st. And I think they were in different time zones, which is why he would be like an hour late. It was ridiculous. But the point is, visually, you kind of pack a punch to kind of get all the stuff into one screen. I do like to do opening statements. This is a different case. It was a legitimation case. This was my opening statement. And then this was my closing statement. And this is the thing case. So it changed. So this shows what I asked for in the opening and what I asked for in the closing. And I find it very, very helpful in a case where a judge knows, because some people have the same opening and the same closing. And sometimes I'm saying to myself, like, were you here for the trial? Like, your client just admitted to 8 DUIs. He's not getting custody. Like, sometimes your ask is going to change based on what happened at the trial. And it should, because if you are just blindly presenting what your client wants in spite of the evidence, at some point the judge just stops listening to you and it becomes white noise. I don't want to be that attorney. I feel like when I walk into a courtroom, a judge knows that what I asked for, I might not get it, but it's at least going to be reasonable in light of the evidence and what has happened at trial. So this is an example where I could show the judge, well, this is what I asked for in my opening statement. This is what I'm asking for now based on the evidence. In this particular case, there's just something that I didn't know, which is, I think he lived with his brother, and his brother had children the exact same age as his children. So he just wanted a schedule that coincided with the cousin's schedule, which made perfect sense to me. And I was happy to accommodate that request. So being able to show, you know, our ask was changing based on what happened in the trial, I think was pretty helpful. Let's see the next one. Demonstrative exhibits, I use them a lot. What I do like about showing them visually is that you can zoom it up, because a lot of times people all of a sudden go blind when they're on the stand and you have a piece of paper and they pretend they can't see it. Obviously, if you are showing something online, you can blow it up as much as you need to, and they can't possibly claim they can't see it. So this was a powerful exhibit that I used in a case where she was asking for alimony, claiming she had no income, when very obvious she had income in staggering amounts. So visually, this was pretty persuasive. Let's see. I've already talked about that. So PDF portfolios. I love PDF portfolios. So when I'm presenting my exhibits, most people have stuff in PDFs, but they have them in Dropbox. And I've seen a lot of times when people are clicking in and out of Dropbox just to share them on their screen, and that is a complete waste of time. So if you create a PDF portfolio, you can get all your exhibits together, create a portfolio, and then you can just click down the list. So all of my exhibits will be on the left with the name, and you can just click, and just fly through the exhibits very, very quickly. And I think actually judges love how efficient I am, because some of them don't really like technology, and the longer it takes, the more frustrated they get. So definitely use PDF portfolios if you are displaying your exhibits or you presenting virtually. I just think it makes it for a much better presentation. So that is about it. I have some other slides about tools and resources and books, and that's it. Does anybody have any questions? I can't believe you guys hung in there that long. I'm doing this in person on March 17th, and I had no idea how long this was going to take. So yeah, I did it in about 2 hours. So
Not a question, just wanted to say thank you. And I think the presentation is excellent, very
oh,
comprehensive.
sure.
You've
Thanks.
done an incredible job and answered a lot of questions that I had just in the presentation itself. So I just wanted to say hats off to you and thank you for presenting this to the group before doing it in person.
Sure, no problem. Yeah, I'll definitely probably have some tweaks to it. There's some things I could probably clean up a little bit, but yeah, I just kind of wanted to give it a test run. Does anybody else have any other questions? Stop sharing. No. Okay, well, I will stop recording. Maybe. Where's the button? Oh, there it is.